So we're very appreciative of Tzvika, professor of law, a scholar, a gentleman, a dear friend, and he's agreed to present this topic to us. I'm looking forward to hearing what he has to say today. Very important topic.
Thank you, Rabbi Hertzfeld. So this shir is a continuation from last week. And just like last week, I have to begin with a disclaimer, which is I'm really learning with Rabbi Hertzfeld right now, and everyone else hopefully can join in. I'm not a scholar of Jewish law. I'm more of a balabait who's trying to apply his knowledge of international law to something I care very deeply about, which is Jewish law. So last week, just to recap briefly, we introduced the primary paradigms in the Torah for the legality of reprisals, and we gave an overview of the biblical prohibition of murder. And we started, if we're going to allow belligerent or wartime or non-wartime reprisals, which will involve the killing of innocents, we have to get around the general prohibition of murder. Because we saw in the Gemara and Tractate Sanhedrin that we don't know that one person's blood is redder than another's. And we looked at a few of the different poskim, halachic poskim from the 20th century, and even though most poskim today would agree that in a time of war, action that is necessary for self-defense, for the collective self-defense, can take the life of innocents for reasons which we'll get into. There are those who disagree, such as the Satmar Rebbe and the Panovich Rav. And then we went to the general authority to use force in war in the Gemara, and we saw it reflected in the Mishnah Torah. And we also saw the halachot mainly around Parshat Re'eh and Parshat Ki Teitzei, about the general rules of law. When you go out to war, then protect the trees. Don't take a woman to be your captive without going through the following preconditions, etc. And we learned about how these halachot are applied not just in war, but in our everyday lives from the great Baal HaChinuch. And we saw that in Sefer Dvarim, there was also a mandate for total war in the event of the 7 nations plus 1, the 7 nations in Canaan plus Amalek, which we read last week. And for those, we don't even make peace. Today, we're going to talk about really briefly, really intensely briefly, what the lay of the land is in international law, so that we can provide a Jewish perspective. Jewish law does not have as robust a legal vocabulary for the laws of war than secular law. So we start with just a lay of the land with secular law, and then we'll see how Jewish law deals with those issues. Again, this is a very brief overview, so I'm not talking about the nature of statehood. I'm not talking about the sources of international law, the laws of occupation, terrorism, aggression. I'm just giving you a very basic overview and lay of the land when it comes to international law. So let's talk about reprisals. Why are we talking about reprisals? What are reprisals? So reprisals are an act of recourse to force to an unlawful act by another state. So one state does something illegal, so illegal that I feel as the other state, I must respond with force. My forceful reprisal is what we're talking about. The interesting thing about reprisals, which we will not get into, but we'll just note for international law, and it's not just for Jewish law, is reprisals really represent the dividing line between having law that regulates state conduct and not having law that regulates state conduct. Because if you look at reprisals, this act, as long as there have been states, states have used force to enforce their rights, either through war or measures falling short of war, such as reprisals. So reprisals have always been around. But it's interesting that they were never codified. There is no code of international law in any source that is signed by the majority of states that expressly regulates reprisals. So if you look at the first code that deals with reprisals, it's the Lieber Code, which is a domestic law of the Union Army from 1863. And it says in Article 27 that the law of war can no more dispense with retaliation than can the law of nations. In other words, we'd love to get rid of reprisals, but we can't. So what are we going to say? Article 28, retaliation will therefore never be resorted to as a measure of mere revenge, an eye for an eye, but only as a means of protective retribution. So I'm trying to enforce my rights, and I'm trying to deter future violations of my rights. That's how the Lieber Code deals with it. A century later, it's a little bit more sophisticated but still we're dealing with domestic military law. The U.S. Army's Field Manual, 1956, defines reprisals as the act of retaliation in the form of conduct which would otherwise be unlawful, resorted to by one belligerent against enemy personnel or property for acts of warfare committed by the other belligerent in violation of the laws of war. And here's the key point: for the purpose of enforcing future compliance with the recognized rules of civilized warfare. So you have law, and you have a general prohibition on the use of force, and somewhere in between, we have this thing called reprisal, which is our way of making sure that other states don't violate our rights of security in particular. So the first implicit treatment of reprisals is not a treatment of reprisals at all. It deals with the general use of force. It comes in 1945 with the UN Charter. And there are two things that we're going to say. There's a general rule, and much more importantly, as any lawyer will tell you, what are the exceptions? So the general rule we find in Article 2.4 of the UN Charter, which says that all members shall refrain in their international relations from the threat or use of force. So we're basically saying that, generally speaking, no state shall have the right to use force in order to resolve their international disputes. That's your general prohibition. Now, the exception comes in Article 51 under the binding chapter of Chapter 7, and this is where lawyers make their money. So notwithstanding anything ever said anywhere else in this charter, nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. So you have the general rule, Article 2.4, prohibition on the use of force, unless you can always use force for self-defense, and the self-defense rules are inherent. So does the UN Charter change the law of self-defense? So it's only if you're responding to an armed attack? Or is the United Nations Charter recognizing a pre-existing right of self-defense, whatever that right of self-defense is? So you have the general rule, prohibition on the use of force, including presumably reprisals. And then you have the exception, which is nothing in this charter shall impair our inherent right of self-defense. Okay, so that's the law of making recourse to war. Now we're going to go a little bit more quickly when it comes to the laws. Now we're in war. So the laws that generally govern the use of force in war, that's called the jus in bello. It goes by many names: laws of war, laws of armed conflict, international humanitarian law. These are the questions of how much force can be used in a war. So there were 4 Geneva Conventions passed after the Second World War, the fourth of which is the main document, and it has 2 particular provisions we're going to talk about. First is the Common Article 2. It's called Common Article 2 because the same Article 2 applies to all 4 Geneva Conventions. And it says that if there's a war with more than 2 parties, and one of the parties in the war is not a party to the Geneva Conventions, the other parties of the war who are parties to the convention shall maintain the level of law and legal warfare with regards to those in the convention, but not necessarily to the ones without. So let's say you have Barry, Shmuel, Rabbi Herzfeld, and myself are in a war. Rabbi Friedman and Rabbi Herzfeld are parties to the Geneva Convention, and I'm not. In their interactions with me, they don't need to comply with the Geneva Convention, but in their interactions with themselves, they have to. The point being, there's this principle of reciprocity. The laws of war govern to the extent that they're reciprocated. Okay? And then you have Article 147 that deals with grave breaches. And if there are serious grave breaches of international law, then they are not just, they're a more serious offense. And that was what we left it there. And then everything changed in 1977. This is the beginning of what I call postmodern international law. If modern international law codified the laws of war, postmodern international law had a different agenda. If modern international law was reciprocal, postmodern international law was about individuals and protecting individuals. If modern international law was about states, postmodern international law is about individuals. So now let's look at the additional protocols to the Geneva Convention passed in 1977. For those of you who weren't around, 1977 is a time of post-colonial legalism, where international law is really coming to redress a lot of the iniquities that were caused by colonial rule. And you see from the beginning, from the preamble and the first article of the additional protocol, what we're talking about here. Look at paragraph 4. The situations referred to in the preceding paragraph include armed conflicts in which people are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. So now we're imposing these restrictions, these additional protocols. We're imposing these restrictions on states, not just when they're fighting other states, but even when they're fighting their own citizens who are fighting for reasons of colonial domination or self-determination. So this is a paradigm shift away from the reciprocity of the Geneva Conventions. And we start to talk about all sorts of objective standards like proportionality and not killing excessive civilian population. And in Article 57, making it illegal to undertake an attack that may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination of, which would be excessive in relation to the concrete and direct military advantage anticipated. This is the famous principle of proportionality, not called proportionality, but identified, again, not for the sake of reciprocity between states. And as a result, the main warring parties, such as Israel and the US, not parties to the additional protocols. Yes, parties to Geneva 4, not parties to the 1977 treaty. So moving right along, we have a problem with the postmodern laws of war because they don't address the problem of asymmetry from a state's perspective. What is the problem of asymmetric warfare? The problem of asymmetric warfare that Israel is dealing with and we're about to address is that at the end of the day, we're fighting people not only who are not bound by the treaties, but who use the treaties as weapons. They know that you're not going to target civilians, so they embed themselves in civilians. And they use the laws of war as a weapon, as a cynical weapon. That's the problem of asymmetric warfare. The additional protocols don't care about asymmetric warfare. All they care about is doing their utmost to protect civilians. So Geneva 4, so the additional protocols to Geneva 4 don't base themselves on reciprocity. Instead, they set out international standards that always apply, irregardless of who your enemy is or what your enemy is doing. Okay, so now we have a basic understanding of what the reprisals are, how international law addresses it using two models. You have the Geneva model, which is reciprocity, and that does not specifically address reprisals. And then you have the additional protocols model that is all about protecting civilians. Okay. With that framework, let's enter into halacha. So, like international, yeah.
So I just want to clarify. So Israel never agreed to enter into this treaty about that it has to act in a symmetrical manner.
Israel never agreed the additional protocols. Israel did not apply the additional protocols as by way of treaty law, but Israel says there are some provisions of that treaty that are law, not because they're treaty, but because of state practice. Because some of the provisions there are not just agreed to, but they're actually reflective of what states do, right? So states do undertake proportionality. States do only use force when necessary and proportionate. So to the extent that they do that, then the additional protocols is right. However, right, the wording of the doctrine of proportionality would be very different if articulated by an Israeli international lawyer and by, say, a Swiss international lawyer. And the reason is the Israeli international lawyer would focus on the subjective standard of the military commander in the field, who has to say this action is necessary and it appears that it will not result in excessive civilian casualties. It's the standard taken by the commander in the field, right? Whereas the Geneva lawyer would say, it's not about that subjective standard. We can look afterwards and we can say, oh, he was clearly wrong. That was clearly too dangerous. It was clearly excessive and therefore criminal. It's an objective, not a subjective standard. So the AP standard, Israel never agreed to. But the idea that attacks must be proportionate, Israel does agree to. You understand? So the treaty, Israel does not apply as a treaty. However,
but they practically speaking are careful.
Sorry?
Practically speaking, they're careful about it.
They're very careful. They're just not using the same standards because the standards of the additional protocols are too high. They don't allow you to win battles. The standards of the additional protocol are only there to protect individuals, which is a beautiful thing. But because they're not based on reciprocity in an asymmetrical context, your enemy will use the law to weaken you. Whereas if both of you are adhering to the same law, then you're both weakened equally. So it's different. The Geneva law says only apply the treaty if both sides are using it. AP1, additional protocols, says you have to use objective standards, objective international standards, no matter what the other side is doing. Because the laws of war don't come to protect states. The laws of war come to protect individuals. So Jewish law deals with this very, very differently, and I think deals with this much better. So let me tell you how Jewish law deals with this, and let's talk about the two case studies in the Torah. Case study number one is the case study of Midian. Now, this is the case where after Pinchas and Cosby, we see that as a result of the promiscuity of Midian, Moshe and Pinchas go out and carry out an act of reprisal against Midian. And when they defeat the Midianites, and then they come back, and Moshe says, hold on, you have spared every female. You kept all these women alive. Why did you do that? Moshe is upset that they didn't kill enough people in their victory. So that's case study number one. Why is Moshe upset that they didn't kill the entire, not the total war, right? And no, Midian is not one of the 7+1. not one of the 7 nations that were commanded to annihilate, or Amalek. So why does that happen? And the second case study, and the much more important case study in terms of how religious Zionists grapple with Jewish law as applies to the use of force, is the rape of Dinah. So when we talk about the rape of Dinah, I'll just say it happens in 5 steps. Step number 1 is that Shechem rapes Dinah. Shechem seems to have fallen in love with Dinah, so it's a little bit complicated. He's not just raping a woman. He wants to marry her, right? But I think we know today that the way to a woman's heart is not by raping her. And in fact, that's exactly what happens. Shimon and Levi say, you can't just take our sister captive just because you fell in love with her. And they take it upon themselves through a ruse to trick the entire nation of Hamor and Shechem. They say, if you circumcise yourselves, we'll allow you to enter into a treaty with us, and you can take our sister. So on the 3rd day after the bris, when they're all in bed and suffering and weak, that's when they come, they save their sister, and they destroy the entire town. Total war, they kill everyone. They pillage the town. And then they come back, and there's a response from Yaakov, and Yaakov says, "Vayomer Yaakov al Shimon ve'al Levi, achartem oti la'avisheni." You've embarrassed me with your total war. And Shimon and Levi respond, how do you expect us to stand by when our sister is treated like a harlot, right? So and Yaakov is quiet for another 40 or so years, and then we get to the epilogue in the end of Sefer Bereshit. Yaakov on his deathbed comes to bless his children, and there are 2 children he does not bless. What does he say? He says, Shimon and Levi, pasuk 5, ahei, are a pair. Their weapons are tools of lawlessness. Let not my person be included in their council. Let not my being be counted in their assembly. For when angry, they slay a man, and when pleased, they maim an ox. These guys are wild, they're uncontrollable, and they're cursed. So what we see here, right, is we see Dinah wrongfully raped and kidnapped. The response is total war by Shimon and Levi. Whether it's right or it's wrong, Yaakov disapproves. At first he's quiet, and then he curses. Okay. What does Rambam have to say about this? So Rambam says that because Shimon and Levi, because Shechem and its community had no law and order, they had no judicial system, which is a violation of one of the 7 Noahide laws, they were collectively responsible for the rape of Dinah and entitled to be killed as a result. Ramban comes along and says, hold on. That Noahide law of setting up a judicial system is a positive commandment. You don't get individual, let alone collective capital punishment for not setting up a judicial system. So what are you talking about, Rambam? And then the Maharal gives a third gloss, and the Maharal says it's sort of a compromise between the Ramban and the Rambam. He says it's true that the people of Shechem cannot be punished for the acts or the sins of their leaders. However, they were complicit. They were complicit, and the reason why they were complicit is because of the principle of reciprocity, which is at that time the laws of war were governed as such that when the leader did something wrong, everyone was responsible. That's not a halachic principle, says the Maharal. That's a secular social principle. And because Shechem and Hamor lived by those rules, Israel had the right, not necessarily the obligation, but Israel or Shimon and Levi had the right to use those same rules against them. Now, with that in place, we go to Kibbia. Kibbia is the Israeli example of how we deal with Jewish law in times of reprisals. So I'm contrasting Kibbia to Deir Yassin. I'm sure you heard of Deir Yassin. Deir Yassin is in 1948, where it was a massacre of an Arab town, not a reprisal. And that was roundly condemned. So I'm not saying Jews are always right, and I'm not saying rabbis always justify everything Jews do. Kibbia was complicated. Kibbia was complicated because it came in a response to multiple acts of terror that emanated from the same town in the West Bank, which was then Jordan. And so now it's a little bit more complicated. It's roundly condemned by the United Nations, but that's not as important for me. What's important to me is how did the three main religious Zionists in Israel deal with this issue? 1 minute each, and then we're done. Professor Yeshayahu Leibovitz says anyone can justify the actions of the Israelis in Kibbia. Heck, he wouldn't have said hell. Heck, the US dropped bombs in Hiroshima and Nagasaki. So this is the way of the people. But remember the case of Dinah, what Shimon and Levi did was legally justifiable, but they were cursed. And we shouldn't live by that curse. We are Jews. We should be held to a higher standard. Rav Shaul Yisraeli, who's the Rosh Yeshiva, later Rosh Yeshiva of Merkaz Harav, and the intellectual heir of Rav Avram Yitzchak and Tzvi Yehuda Kook, he says there's no need to have higher standards than the enemy. If you have higher standards than the enemy, you're just going to shoot yourself in the foot. And he explains the Rambam and the Ramban by saying what happened with Dinah was that Shimon and Levi had the right to respond, but Ramban didn't like it because ethics require you to do more than what the law requires. So Shimon and Levi had to get Dinah back, but Yaakov was upset with how many people they killed. So same thing with Kibbia. Kibbia was that we had to save our citizens, but what the law that applies, says Rav Yisraeli, is secular law. It's international law. It's the law of reciprocity. Okay? Now that takes us to the third main interpreter of Jewish law when it comes to reprisals, and that's the chief rabbi and later the chief rabbi of the Israeli army and later chief rabbi Ashkenazi, chief rabbi of the state of Israel. And Shlomo Goren says that the law of the Torah and halacha is immutable. It's just been in disuse for 2,000 years, and he took it upon himself to bring the halacha into the army. And he basically said that international law, that's not for us. We need a Jewish law. Where he disagreed with Professor Leibovitz Professor Leibovitz said that Judaism did not have a unique ethic. It just showed you to the universal ethic. But Rav Goren said, no. Judaism had a unique ethic, and we have to apply that ethic. And for example, if we're besieging a town, we always need to leave a way out. That's the Jewish ethic. And so those are your three models. Model number one is Professor Yeshayahu Leibovitz. We have a higher ethical code. Model number two is we have Rav Shaul Yisraeli, which says, no, this is really about international law. And then you have model number three, which is Rav Shlomo Goren, which says we have Jewish law, which is better than international law that has to apply. And what's beautiful about this halacha, this halachic approach, is because no matter who you go, whether it's Rav Yisraeli or Rav Leibovitz, you know what to do even when you're dealing with asymmetric warfare. And I'm happy to continue the conversation, but I wanted to make sure I got through everything, and now it's Mincha Marav.